We are done with this substantive and procedural part, plus the intro, right? Like what is there in IPC. Now, Indian Penal Code, right? It talks about different types of offenses which may be committed in India, where it provides for like a definition. It talks about the ingredients or elements for commission of that crime, plus it also provides for the punishment. Okay, so whatever section you look for, it will always provide for the punishment also. That for so and so crime, this is the minimum, this is the maximum punishment that may be given. Now, one very important...
Crime plus punishment.
Yeah, sorry.
Crime plus punishment.
Yes, crime plus punishment. So everything is given in IPC itself. Now, when we talk about this unit one very important part from that is punishments, like types of punishments that are there in IPC. Questions are also framed from that part. So we will discuss that today. Okay. So it was there in 2021 exam itself, the March and April part, where there was one question: explain various types of punishments to which offenders are liable under IPC. Under some different legislation, in different laws, other types of punishments may also be provided. Like in case of civil suits, different types of punishments are there. Like we saw yesterday, there may be compensation or damages which may be provided. There may be specific performance of contract that can be asked for, and so many different types. But what are the types of punishments that are mentioned under IPC? We are only concerned with that part. Okay, so now we'll discuss this thing. In general, if you talk about punishments, okay, why are punishments given to the offenders, to the criminals? There are certain theories on that also, that what is the purpose of giving punishment? Is it because we want to prevent that person from repeating something similar? Is it because we want to set an example in front of other like-minded people that if you commit this kind of a wrong, this is the consequence that you will have to face? Or is it that we want to reform that person? What is the purpose of giving punishment? For that, we have different theories, like 5 different theories are there, which you will study in jurisprudence. That's a different subject. But now we are concerned with punishments given under IPC, Indian Penal Code. Now, the main purpose of giving punishment is like 2 reasons are there. Okay, in criminal law in India, there are mainly 2 reasons why punishments are given. Any idea what may be the reasons why punishment is given in India for crimes?
To set an example.
To set an example, correct. Anything else? Correct. We want to set an example. That is why even we have the punishment for death penalty, that in rarest of rare cases, which are like very severe, very heinous, their death penalty may also be given. It will be like an example that if you commit something like this will be the punishment. So correct. To set an example for other like-minded people, punishments are given. Another reason is reformation. We always think that, like it's said, right? Mahatma Gandhi said, hate the sin, not the sinner. Like a person is not born a criminal, but because of situations and because of so many other reasons, the person ends up committing a crime. So we need to give like an opportunity to the person to reform himself. And it is assumed that it's always possible that a person may reform into like a completely different human being. So just because someone has committed a crime, death is not the only punishment that we have, but death should be only in rarest of rare cases where it's like very serious kind of an offense that cannot be forgiven, or a lesser punishment would not justify basically. Otherwise, we can provide an opportunity to the criminal also, so that the person can reform himself and again like start his life. All right, so that is the main purpose of giving punishment in criminal law in India. Set an example and give enough opportunities to the person to reform himself, like self-realization. Person will realize that I have done something wrong, and the person might reform himself. Okay, so punishments, when we talk about punishments, there are mainly 6 different types of punishments that are provided under IPC. First being death penalty or capital punishment. Second being imprisonment for life. Third also is imprisonment, but it is not for life. It will be for some fixed period, and that time frame also will be mentioned. Okay, so that imprisonment for life, then imprisonment for a fixed period, which might either be rigorous imprisonment or simple imprisonment. Next is forfeiture of property. Next is fine. And last one is solitary confinement. So these are 6 different types of punishments that IPC talks about. Whatever crimes we get under IPC, either of these will be the punishment which is mentioned there. And we need to look for the specific sections to see what all punishments are there. Now, there are 2 very important sections that we need to remember for punishments part. First one is section 53 that talks about these first 5 types of punishments, that is death, imprisonment for life, rigorous or simple imprisonment, forfeiture of property, and fine. These 5 types are given in section 53, and the last one, solitary confinement, is given in section 73. So together, both these sections taken together, we have 6 different types of punishments mentioned under IPC. Okay. So first one being death punishment or death penalty. Now, what do you think? Is public hanging still allowed?
No.
It is not allowed. Why so?
It will public will disturb, that's why.
Public will disturb. Okay. So like under Constitution, right, we have different articles. So there is one article, Article 21, which provides a fundamental right. Okay, right to life and personal liberty. Article 21 says that we have a right to live a dignified life. When we say right to life, it does not mean mere animal existence, that somehow we are surviving. It's not like that, but we have a right to live a dignified life. And this right is available even to a person who is death convict, like for whom capital punishment is given. That person also has Article 21 to live a dignified life until his last breath. Okay, so it is said that public hanging is like against his dignity. The person would be, like it would not be, person will not be comfortable. Fine, he has done something wrong. He has committed like a heinous crime, but still the person, fine, it's fine, death penalty is fine, but he should be allowed to die in a dignified way. It should not be like a public display or some exhibition sort of a thing. That is why public hanging is not allowed nowadays. When we were in school, it used to be allowed, right? We saw so many things on news also, but now it is not allowed because of Article 21, that we have a right to live a dignified life. It's not just animal existence. So death penalty, it's also known as capital punishment, where a person is hanged till he dies. And in the judgment also, it will be mentioned, hang this person till he dies. That means you can try like as many times as you need, right? You can try to hang the person. If something goes wrong, the person is not dying also, you can try again and again. Hang this person until he dies. This is how it is written. Previously, right, it used to be like, okay, like hang this person. So once they will try, if something goes wrong, the person do not die in the first attempt, it will be assumed that might be the person was innocent. That's why like God is saving him. So we cannot like punish a person twice for the same wrong, right? It's given under Constitution also. For one wrong, only once you can punish. So there was no option of trying it again and again. Once only you can try. If the person dies, fine. If the person somehow is able to survive, you cannot try it again. But now in order to correct that thing, it is said that hang till he dies. As many number of times as needed you can try. The person should finally die. That is the punishment which is like provided. Okay, so now whether death penalty is good or not, whether death penalty should be there or should not be there, there is a lot of debate that we have. Okay, there are arguments for death penalty plus against death penalty, and we cannot as such conclude that death penalty is very good or very bad. It will have its positives and negatives as well. So there was this Ajmal Kasaf case, if you remember, Mumbai Taj Hotel attack, right? Yeah, so that was like very much in news, right? That this person was given that penalty. That time in all, like law courses and everything, this was the main question which was asked. Give points in favor and against the death penalty. Okay, like people had to write. It was like that much common topic. Okay, so death penalty as such, we have arguments in favor or against. There is in fact one convention. I'll just give you the name. It is called Torture Convention. So all these international conventions are there, right? So these conventions are as such not binding on all the countries unless and until they ratify it. Okay, like the countries need to ratify that convention, only then it becomes applicable to a certain country. So there is this United Nations Convention. Okay, it is called as Torture Convention or United Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment. Now, there are so many countries which have ratified that convention, but India has not ratified it. Why? Because in India, we still have the provision for death penalty. If India ratifies that convention, India will have to like remove this provision of death penalty from its domestic laws. Like from IPC, we need to amend IPC. We need to remove the punishment of death penalty. And that's the reason why still now India has not ratified that convention. Okay, that also you can write in your answer that this convention is there, which is not being ratified because having this provision for death penalty in the rarest of rare crimes makes sense. Okay, so that is the reason why it is still there. Now, there was this case, Jagmohan Singh versus State of Uttar Pradesh. It's a case of 1972, wherein it was said that death penalty is unconstitutional. Constitution of India is providing for right to life under Article 21. And then under certain sections of IPC, right to life is taken away from people. So it is unconstitutional. It is going against the constitution. That is how it was like argued in front of the Supreme Court in an appeal that it is unconstitutional. It is going against our rights. But then a constitutional bench of Supreme Court. Are you aware what is a bench of court? Bench of
family. Single bench, single judge, double judge, and like that.
Yes, correct. So how many judges are sitting to decide on a
Sitting in
certain? Yes. So it may be single judge bench, it may be divisional bench, or it may be constitutional bench. Constitutional means there are 5 or
Only
more than 5 judges. It may go up to any number of judges. 5 is the minimum. It may go up to any number. So what is the highest number of judges who set to decide a case? Any guesses?
7. 7.
7. Which case?
Ayodhya, I think Ayodhya is 3.
Okay. It is 13 judges bench. It was case Vananda Bharati. That is like the highest number of judges who have said to decide on one single matter. Okay. So in this certain case, because like mostly, right, when a certain question is relating to constitution, some matter is there before the court, it will be referred to a constitutional bench. Like 5 or more than 5 judges will be there to decide on it. Because in this case also, it had to do with Article 21 of Constitution. It was referred to a constitutional bench of 5 judges, and they dismissed the appeal. Okay, what is the meaning of dismissed?
The convict Jagmohan Singh was appealed for removal of death penalty. The judge has dismissed his appeal and stay what the previous order, I think.
Yes. So basically there are 2 things. It may be disposed or dismissed. Disposed as in this entire trial has been completed. All the stages have been completed, and dismissed means maybe starting of the case only, or in between it just ended abruptly, right? Judges felt that might be this is not having enough importance. It's not like a making a proper case or something, or maybe parties have approached a wrong court or something. Okay, so court will basically say that no, this matter is dismissed. We are not going through all these stages of trial because we don't think it makes sense. Same happened here also. His appeal was not heard, like all these stages were not completed because court felt that it's not unconstitutional. That sentence is not unconstitutional because if you look at Article 21, it clearly says that right to life and personal liberty, but except according to procedure established by law. Otherwise, you cannot take someone else's life. It will be called as murder or some other crime, but if it is done with the procedure established by law, with some process that law allows, it is constitutional. So under Indian Penal Code, law has allowed judges to provide death penalty and take life of people who has done some kind of an offense that is valid and justified. So it was allowed that, okay, fine, in such a case, it will be constitutional only, and it does not make much sense to hear this matter, so appeal was dismissed. So this is one case. And if you look at the Indian Penal Code, like the BEREC, there are so many sections for which death penalty may be given, like waging war against government, fabricating false evidence with intent to procure conviction of capital punishment, murder by life convict, abetment of suicide of child or insane person, attempt to murder, so many types where death penalty may be given. Plus, there was
in
one
exam, we should write a separate case law for everything, every crime.
Like every crime, as in?
Yeah, against war against government or state, like for this case law, like that.
I don't think it will make much sense in this question, because question is punishments, what all types of punishments are there. So might be one or two cases you can write for each punishment, but in death penalty, if you are writing multiple cases for all these sections, that does not make sense.
Okay.
Okay, these two I am giving because it's like landmark cases, so I have added. But yeah, you don't need to write so many cases because question is focusing on types of punishments, right? So you can explain more on different types of punishments, maybe some other cases relating to different types, like that you can write. So another case is Bachan Singh versus State of Punjab. It's again a case of 1980 that upheld validity of death penalty, but court restricted the provision of death penalty. So court basically said that, yeah, under Article 21, Constitution clearly says that right to life may be taken away by a procedure established by law. But this should be used only in rarest of rare cases. It should not be that any case of murder, death penalty is only given. Person should be given opportunities to reform himself. Like we said, what is the aim of providing punishment? Reformation is on the topmost priority. Okay, so in rarest of rare cases, it might not be justified to give other punishments. There only we should be giving death sentence. So capital punishment may accordingly be given. There was one very like a landmark case this year itself, 2021. It is Shabnam versus State of UP. Have you heard of this case where one couple, they killed some 7 members of the girl's family and both were given death sentence? It was very much in news. If you have you heard this?
No.
No. Okay. So what happened here, right? There was like a girl, Shabnam, okay, from state of UP. So I think Shabnam, yeah. So Shabnam was like belonging to Muslim community, and there was another person. So Shabnam was like very well qualified. She was working as a teacher in some government school, and her entire family was like in teaching, doing good and everything. So she had an affair with a boy who was not like from a well-to-do family. So her family was not accepting him. Okay, so she was having an affair with this person, but her family was not accepting their relation. After that, few months went and then she was pregnant and still family was not accepting it. So in her family, there were like father, mother, I think brother, and like sister-in-law, some small kid was also there. Okay, like total 7 members were there. So one day what she decided is, after having dinner, right, with the entire family, she gave some medicine to this entire family. Everyone slept off, and then she called her boyfriend, and both of them together, right, killed the entire family along with the small kid who was there. So they killed all of them. And after that, there were like some like conflict between this couple also. So she was saying that her boyfriend killed her entire family, and he was saying that no, Shabnam killed, and everything went before the court. And finally court also like came to know that both of them together like killed 7 members of the family, including one kid. So court said that it's like a rarest of rare case only, where in one night itself, like 7 members of one family were killed, including this small kid who was not having any idea of what was going on. So that sentence was given. They appealed in the High Court, appealed in the Supreme Court. It was not accepted. And by the time, Shabnam also had a small kid also. So she was like, okay, fine. He can be given death penalty, but I should not be given because I need to take care of my kid also. But finally, like court refused it. Then she went to governor also, president also, everyone rejected her mercy petition. So I think it is like execution is pending, but yeah, that sentence was confirmed for that case. That again falls under this rarest of rare category that you can mention. It was like a very famous case of 2021 that also you can mention over here. Okay, that in such cases, yeah, it makes sense to give that penalty, because obviously like it does not make sense, right? What care would she provide to the kid also? Like someone, like one of her friend was already taking care of the kid anyways, So court was like, no need, you cannot do any, like any good for the kid, basically. So like that, some cases it is justified, basically. That is what you can mention. Next one is imprisonment for life. Now, when we say imprisonment for life, life means the remaining life of the person, right? If a person is given imprisonment for life at the age of 20 and the person survives till the age of 80, that means remaining 60 years, he should remain in jail only, right? Imprisonment for life. That is what the common understanding is. But is it actually imprisonment for rest of the person's life? What do you think?
I think some certain time or certain period.
Okay. So usually when we say imprisonment for life, it indicates that, yeah, for the rest of the life. But then governor as well as president under constitution are given some powers, like mercy petition. They can, like mercy on the ground of mercy, they can say that, okay, fine, no need to give death penalty, some other punishment may be given, right? Like that, there are other things also, like pardon and commute. They can forgive that, okay, fine, you don't need to remain in jail for the rest of your life. Maybe 14 years, 15, 16 years is also fine. Remaining thing is excused. Or maybe it is substituted from higher to lower punishment. From death, like imprisonment for entire life, it was reduced to maybe 14 years of imprisonment or something. Okay, so that power is given to governor as well as president, that they can reduce the punishment also. It makes sense because like prisons are already overcrowded. There are so many crimes taking place, so many people in prison, and it does not make sense, right? Remaining 60 years of life, keeping a person in prison, when we are approving on the theory of reformation, that everyone can reform themselves. Then fine, some years you keep the person, after that maybe the person is able to reform himself into a better human being, so let him contribute to the society rather than keeping him in the prison, right? So that is what it is. Imprisonment for life, it actually means that imprisonment for life actually means like rest of the life, but there is this provision of reducing it or excusing it. So minimum for 14 years. Okay, if life imprisonment is given, minimum for 14 years a person should remain in prison. After that, it may be excused, it may be removed also. Okay, so minimum term will be 14 years. And for the purpose of calculation, like certain times we need to calculate what will be the number of years of punishment. So for the purpose of calculation, life imprisonment is calculated as 20 years. That if we are saying that life imprisonment is given, it will be 20 years, like that it is calculated. But minimum for 14 years, the person should remain in prison. After that, he can ask for, like pardoning of his punishment. And after 14 years, there is a possibility that person will be released from prison. Okay, is this part clear?
Yeah.
So imprisonment for life, this thing we need to remember. It cannot be less than 14 years. For the purpose of calculation, it is calculated as 20 years. And when it is imprisonment for life, it will always be rigorous imprisonment. It cannot be simple imprisonment. Okay, these are three things that you can remember. So second one was like imprisonment for life. Now we have one more type of punishment, which is imprisonment. That means we are already fixing the time frame. Is it for 5 days? Is it for a month? Is it for 2 months, 2 years, 5 years, whatever? Time is also being fixed. In that case, it will fall under this third classification. So imprisonment means taking his rights and putting the person in prison. Section 53 of IPC provides for two different types of punishments. One is simple imprisonment, another one is rigorous imprisonment. Now, when a person is in prison, if the person is simply like kept inside a room, not doing anything, the person would go mad, right? And also after completing his term of imprisonment, the person needs to face the society again, needs to work, survive, earn his livelihood, right? So for 5-6 years, if a person is not doing anything, simply sitting inside one room, it will be very difficult for that person, right? So in such a case, it is said that when a person is in prison, it's not like they would simply sit there. They also have like a proper routine. They also do certain work. Simple imprisonment means the person will be asked to do some kind of like small works. Okay, maybe someone is given imprisonment and that person was like the only earner of the family. So now what will happen to the family? From where will they get money? Right? So that is why they are asked to do some work. From that, they will make some money. If they have some dependents or someone, some portion would be sent to the family. If not, that amount will be collected. At the end of imprisonment term, they will be given that amount so that they can, with that money, it becomes easier for them to start their life again after completing this term of imprisonment. Okay, so usually in case of simple imprisonment, there will be some simple work that people do, like baking cookies, baking cake, or doing some, like DIY stuff and things like that. Okay, so I in fact saw near my house, there used to be one stall where from the prison, right, the inmates will create some, like this handicraft things they will create, and there used to be one stall where it will be written that it is created by the jail inmates of so and so prison. So if people are interested, they can buy it also from there, and that is how the inmates will make some money and it will help them start their life again. That will be simple imprisonment. Have you visited any prison anytime?
No.
No. Okay. Usually for these courses, right, law courses, they take you to 1 or 2 prisons also. I'm not sure because of COVID what will be in your case, but yeah, usually they will take you and then you can talk to inmates and see what all things they do as well. What is their routine and everything. And when we talk about rigorous imprisonment, it's usually something that we see in movies also, right? They are made to break like big stones and everything. Have you seen in movies rigorous imprisonment? In prison, they will do very hard labor. Any movies? Have you seen it somewhere?
Yeah, in old movies I watch in Kannada.
Okay. Yeah. It is very, in old movies.
Software only. No, software and work from home only.
Okay. Yeah, so in old movies, it used to be there that they are breaking big stones and everything. So that is nothing but rigorous imprisonment. So in case of rigorous imprisonment, they will be given hard labor like carpentry, drawing water, then breaking stones and all that stuff. So it is obligated. Rigorous imprisonment is obligatory for offenses given in these cases. Like usually when you read about a certain type of crime, it mentions that these many years of simple imprisonment or rigorous imprisonment. It is also mentioned as well. So this is the third classification, imprisonment, where time frame is already mentioned. It may either be simple or rigorous imprisonment.
Okay.
Next one is forfeiture of property, which means taking property that a person has acquired. Okay, it is like a property which the person has acquired wrongfully and that will be seized by the state. Okay, maybe because a person has acquired some property from like a foreign country, okay, or from territories which is at peace with government of India, there a person has acquired some property. In that case, it is not justified, so government would seize that particular property from the person. It's like forfeiture of property, taking back property from a person. That also is a kind of punishment which is given. Then fifth type is fine, which again is very common type of punishment. And usually we see that for some crimes, right, it will be that fine can be imposed. What amount of fine? No minimum or maximum limitation is given. It is like only fine can be imposed. Their court is free to decide on the fine. Sometimes amount will be mentioned, that fine not exceeding 500 rupees, not exceeding 2000 rupees can be given. So in such cases, court will impose that much of fine. In some cases, it will say imprisonment or fine. That means court will see, depending on severity of the crime, either fine may be imposed or imprisonment may be given. In some cases, it will be imprisonment and fine. That means some amount of imprisonment will be there and fine also will be there. It's not optional, it is mandatory. Like that, we have a lot of different provisions where fine is there. Okay, so it will be decided by the court what amount of fine. Is it a sole punishment? Is it only fine will be imposed? Or is it as an alternative for imprisonment or in addition of imprisonment? Imprisonment plus fine, imprisonment or fine, or is it only fine? It depends on the type of crime which is committed. Plus, when court orders that this much of fine should be paid by the person, there is always a possibility that person may not be in a position to pay the fine, or might be he is not paying the fine. He is in a position to pay, but still he is not paying. In such cases, in the order itself, right, court will write this much amount of fine, and in case of default, this many years or months of imprisonment. That means if the person is able to pay the compensation, well and good, pay the fine, well and good. If not, he will have to undergo imprisonment as well. Okay, that is usually mentioned in the judgments when you read the decision, right? It will be usually mentioned that this much of fine, if the person is not able to pay, this many months, days, years of imprisonment. And the last type of punishment that we have is solitary confinement. So confinement, as in confining a person within, might be like 4 walls. It is solitary confinement. In case of prisons, maybe sometimes 2 persons might be there in the same prison, right? They are able to talk to each other. They are able to see other humans. Solitary confinement means they are kept separately. All by themselves, they need to live. No one is around to talk to or stuff like that. So this is like a severe kind of punishment because it's very difficult, right? Being like, people always want others' company, right? We want to talk to people, we want to see people. So solitary confinement is sort of difficult, and it will have more impact on your brain. Okay, if you are not seeing any other human for a month, it will be much more difficult. That is why there are a lot of guidelines that apply in case of solitary confinement. It cannot be simply given just like that. There are certain guidelines that need to be followed to ensure that it does not end up disturbing mental peace of the criminal. Okay, otherwise it would be like, it will worsen the situation. Rather than reforming the person, it will worsen the situation. So it is provided under section 73, which is like the 6th category. Other 5 types are mentioned in section 53. So section 63 defines solitary confinement, which means keeping the prisoner isolated and away from any sort of interaction with the outside world. Otherwise, in case of jails also, it's not like a very secluded place or something. They are able to talk to each other in a like a group. They will sit, they will have so many different activities, so many different things to do in the entire day. They have like a proper routine. But in case of solitary confinement, there is nothing as such. It is believed that this feeling of loneliness sometimes helps to reform the criminal, because the person is able to realize, like self-realization will be much better in such a case, it is considered. But then solitary confinement shall in no case exceed 3 months in total, because it will be then having like worse impact on the person's mental health. So there are some like 3 guidelines. This is only for your like knowledge. It's not needed that you write this much in exam. Might be these 3 points you can mention, these part you can like skip, because it will be like otherwise too lengthy. Okay, it depends on your writing speed. Again, if you are able to manage, you can write also. So if the term of imprisonment is less than or up to 6 months, less than or up to 6 months, then solitary confinement shall not exceed 1 month. Out of 6 months, only 1 month can be solitary confinement, not more than that. If imprisonment is somewhat between 6 months to 1 year, solitary confinement can be up to 2 months. If imprisonment is more than 1 year, then solitary confinement can go up to 3 months. So up above 3 months, in no case it can be allowed. All right. And depending on the total term of imprisonment, solitary confinement's duration also will be decided. It can be awarded only if the following 2 situations exist. That is, a person must be convicted for an offense under this code. There are other legislations as well, like we have Negotiable Instruments Act, which provides for punishment for check bounce case. Okay, if a person issues a check and that check is dishonored by court and the case is filed, person is found guilty, and might be 2 years of imprisonment is given. In that check bounce case, it cannot be solitary confinement. Solitary confinement can be given only if a person is convicted for an offense mentioned under IPC. Person is found guilty of violating the provisions of Indian Penal Code, there only solitary confinement is applicable. Plus, this offense must be one for which court has the power to sentence the accused to rigorous imprisonment. In case of simple imprisonment, solitary confinement will not be applicable. It will be only for rigorous imprisonment, plus for conviction under Indian Penal Code, it can be provided and not otherwise. So punishment of solitary confinement cannot be awarded for whole term of imprisonment. If it is 1 month, for the entire 1 month, it cannot be provided. Depending on this time frame only, it has to be fixed. It must be imposed at intervals. Together, like 3 months, a person should not be kept in solitary confinement, because otherwise the person will go mad. Okay, so it has to be at intervals. What kind of intervals? A sentence of solitary confinement for whole term of imprisonment is illegal if awarded for more than 14 days at a time. 14 days maximum at one time. When the imprisonment is awarded is of more than 3 months, solitary confinement shall not exceed 7 days in any month of the whole term. So there are all these guidelines that need to be followed to ensure that solitary confinement is able to serve its purpose. It is not having like an adverse effect on the person. Okay, is this part clear?
Yeah.
So these are the 6 different types of punishments that we have, and with an intro and conclusion, you can end your answer. It's usually better that you start with some intro and then end your question with some conclusion. Okay, so that part you can add. And this is how you can write on this punishments.
Okay.
All right.